Well, greetings. My name is Jeremy Farrell, and it's a great pleasure to welcome you to this exciting session with the Honourable Michael Kirby on his experiences as Chair of the United Nations Commission of Inquiry on the Human Rights Situation in North Korea. I'd like to begin by acknowledging and celebrating the traditional owners of the lands on which we meet and the airwaves on which we meet, and pay our respects to the elders of the Ngunnawal and Ngambri peoples past and present here in Canberra, and also, of course, to any Indigenous persons who might be joining us in this discussion today. I'd like to hand over to Richard to introduce Michael Kirby in a moment, but just in terms of the process, how we expect our discussion to unfold, Richard and I will begin by posing a series of questions to you, and then once our conversation reaches a natural endpoint, we'll open up for questions and comments from all of the students. And so please, if you have a question that you would like to ask Michael Kirby, please feel free to put it in the chat line, and we'll turn to you and ask you to turn your video on and ask your question at the appropriate point. A reminder to turn yourself on mute, please, to make sure that the sound works as well as possible for everyone. And with that, I'll hand over to you, Richard.
Well, thank you very much, Jeremy, and we really are honoured, Michael, that you've agreed to once again engage in this In Conversation event, focusing on international dispute resolution in practice, specifically in the relation to the UN Commission of Inquiry on Human Rights in the Dprk or North Korea, which you chaired in 2013 and 14. Students will be very much aware, of course, of the very significant contribution you have made to the law in Australia and internationally throughout your long career, particularly during the 13 years as a judge of the High Court of Australia from 1996 to 2009, when you retired, you were the longest serving judge on that court. But since retirement, or entering into retirement, I know you have been super active in so many fields, particularly in the human rights area, serving on a number of national and international entities and bodies, including those associated with the United Nations. And you've also maintained a very active engagement with universities in Australia. And you mentioned just now that you'll be talking tomorrow to the University of Adelaide. Here in at the ANU, of course, you have a very close association with the College of Law, which established the annual Kirby Lecture on International Law in recognition of your passion and contribution to international law. And this lecture really is one of the most significant events in the legal landscape in Australia. And we hope that it won't be too long before we can hold it in person here on campus. So a very warm welcome to you, and thank you very much for agreeing to participate in this In Conversation event. I perhaps will lead off with the first question, perhaps to ask, how did you become involved in the Commission of Inquiry on the Dprk? How were you approached, and how did you actually become involved?
Thank you very much, Jeremy and Richard, for your welcomes. Let us begin by acknowledging the Indigenous people, as Jeremy has done, and let us also remember James Crawford, because since I last had this conversation, a great scholar and hero of international law and judge of the International Court of Justice, James Crawford, has died, and his death is a really, really big blow. He was the first person who delivered the Kirby lecture, and I was very proud of my friendship with him through the University of Adelaide and through the Australian Law Reform Commission, where he became one of the first full-time commissioners. And it's really a tragedy. And when I've learned that there is an issue as to whether he died in part as a result of a poor handling of a problem which is very common in Australia, which is the problem of carcinomas caused by sunlight, an aspect of climate change, unfortunately, but also an aspect of where Australia is in the world. It is doubly distressing. So with those few preliminary remarks, I'll turn back to the question. How did I become involved? I didn't know anything more about North Korea than the average reader of The Economist. I kept a general knowledge about it, but I had no specialty. And in that sense, I could approach the inquiry with an open mind, some might say a completely blank mind. And that was an advantage, I think, because I didn't approach the issue with hostility to North Korea or with affection for North Korea. I was at a conference of statisticians in England, and statisticians, as we lawyers know, are very clever people. At Macquarie University, when I was Chancellor, the top students who applied for places at Macquarie were those who were joining the statistics and actuarial courses. They were the top in HSC results. So they're clever people, and I was involved in this very interesting conference with them. And I got a phone call, which in the technology available to me at the time, I had to take at the public phone box outside a castle in England where the conference was going on. And I was asked on behalf of the Department of Foreign Affairs in Canberra, would I permit my name to go forward to the High Commissioner for Human Rights to be a member of an inquiry on North Korea. And I said, well, I'll have to consult my partner about this, but prima facie I will. And so I consulted Johan about it. He was not all that keen, but he generally goes along with it. And so he did on this occasion. Generally speaking, that's not the way special procedures of the United Nations are filled. Nowadays, they are generally filled by application and by shortlisting and by a process of interview. But this was a tap on the shoulder. And I think I was tapped on the shoulder because I had been earlier in 1993 to 96, the special representative of the Secretary General for Human Rights in Cambodia. And that was a very, very difficult job. And I think in the UN, they came to the view, we're going to have to short circuit this, and we will ask Michael Kirby, and that they did. And I said, yes, I will. Eventually, I said, yes, I will do it. And I was appointed to be the chair. And Marzuki Darusman, former Attorney General of Indonesia and Special Rapporteur on North Korea, became a member of the Commission of Inquiry. And Sonia Biserko, who was an expert with connections with the United Nations, was the third member. So we three were appointed to be the members of the Commission of Inquiry, and we set to work immediately, and that's how it began.
Thank you, Michael. That's fascinating to hear how you were sort of cherry picked to play that role. Interested to hear what were your greatest challenges as chair of the commission?
Well, the greatest challenge was presented at the beginning when we were appointed. The decision was made by the Human Rights Council, and most unusually, indeed uniquely, it was made without a call for a vote. Now, to set up a COI is a very political thing in terms of human rights. And normally there's a demand for a vote because there are some countries, and they came out of the woodwork without too much delay, which are just in principle opposed to commissions of inquiry because they say this is not how you're going to get progress on human rights. This is going to be hostile, it's going to be adversarial, and it's not a good path. But in the case of North Korea, there'd been so much information that had been filtering out that there was no call for a vote. The president, Dr. Herzl of Hungary, called twice whether there was any motion, and there was none. So he declared the commission established, and that's what happened at the very outset. We convened our meeting after discussions with UN people for the 1st of July 2013. And we had effectively about 8 months to get our report done because we were asked to deliver our report by the beginning of the session of the Human Rights Council in March of 2014. And we delivered our report on time. It was unanimous, and it was immediately a sensation in the United Nations because of the way in which we'd gone about preparing our report. But I think it's a very good report, and in part that's because of the methodology we use. We spent a lot of time talking about methodology and how we would do a credible report when it was very clear we were not going to be allowed to enter. The special rapporteur, Mr. Darasman, had not been allowed in. His predecessor, Professor Munterborn of Thailand, had not been allowed in. We didn't expect to be allowed in. We continued to press to be allowed in. And at the end, when we were attacked, we said, well, let us come in, and if there are any mistakes, we'll correct them. But we were never allowed in, but it didn't in the end create a difficulty because of the methodology that we adopted.
Well, thank you very much. You referred to the methodology. Could you expand a little bit on that, on what actually the methodology was, and how did you actually work around the fact that you were not allowed in?
Well, we knew that there was a big community of escapees. They're usually called defectors, but I never used that word because to defect is to make a sort of political judgment. I just said they're refugees or escapees, and they were about 30,000 who had, during the winter months, walked across the Yalu and other rivers into China and had escaped on escape lines rather similar to the escape lines that Allied soldiers used during the Second World War, which were set up from safe house to safe house, generally down to Laos or Thailand, and out through that way. And if they can get on a plane and end up in Seoul, they have a right under the Constitution of the Republic of Korea, South Korea, to become citizens of South Korea. And so that was the escape line. That was how they got in. And they were available to us. They would be locked up in detention in South Korea for a few weeks, and they would be vetted in case they were suspected to be spies for North Korea. There's great hostility between the two states and great suspicion. But if they got through that, they had certain rights to pensions and housing. And so there were 30,000 people potentially who could help. And we advertised our presence. We advertised that we were calling for witnesses, and we got a lot of witnesses. We interviewed some of them privately because they had family still in North Korea, or they had other reasons of security that made it wise, prudent to see them privately. But most of them were not only willing to, but were keen to speak truth to power as they saw it, and to speak to us in public hearings. We followed the Anglo-American tradition of conducting an inquiry in public. This is a very important feature, one of many, many unusual, peculiar, special, and beneficial features of the system of administering justice devised from Britain. And it's what we do in Australia when we have a royal commission or commission of inquiry. Generally, with few exceptions, they sit in public, like our courts do. And this is all on the basis that if you're trying to solve a problem, you do it better if you are seen to be honest and striving to solve the problem. That if you've got a set piece scenario, it will be revealed very quickly. And so that is how we did it. We did it in public. We filmed the witnesses. We put their testimony online. The testimony is still online. And when, in the end, North Korea attacked the Commission of Inquiry, we said, well, everyone in the world except in North Korea can have access to the internet and see the testimony online and judge for themselves. I invite everyone to go and judge for themselves. And it also meant that we had testimony. We had to have it translated. We had written transcripts in Korean and in Japanese and in English. And that became the foundation of our report. And the report is studied throughout. Every second page has passages from the quoted testimony of the witnesses, because you learn from a judgment in Australia or from a commission of inquiry in Australia. The witness can say things much more powerfully and often much more succinctly than the judge can or than the inquirer can. And so part of the power of this report is that it can, every second page has got the passages from the testimony of the witnesses. And all of this was very different for the United Nations. The United Nations didn't do things that way. The United Nations methodology was the Napoleonic methodology. The United Nations was set up in 1945. They basically followed the League of Nations methodology. That League of Nations methodology was fundamentally quite secretive. And even the British methodology was also rather secretive. They had their Official Secrets Act and so on, but they did inquiries in the open. And that is, of course, part of the power and strength of the inquiry. If you look at our inquiry on child sexual abuse, part of the power of it was done in public, and it came out and the media was present and the media covered it, and it became a scandal for the whole of the nation. Well, similarly, I believe the situation in North Korea became a scandal in the United Nations and a shock to the United Nations system.
What were the most shocking or controversial elements of the Commission's conclusions?
Well, we had a 9-point mandate, and I have to say on every point of the 9 points, there were shocking revelations. It's difficult to pick particular ones. The system of detention camps North Korea always denied that there were detention camps, but the witnesses came forward and they gave evidence, which was they were witnesses who didn't know each other. They had been in different detention camps. They gave exact descriptions of the nearest town, and they gave descriptions of the layout of the camp. Unfortunately for North Korea, well, there are now satellite images, including just Google Earth and commercially available images that permit people to see what the topography of places is. And so you can go in on Google Earth and you can see these places and you can see the layout and you can see the way it has been described. And in a sense, there was corroboration because the witnesses gave testimony of why they had been detained. It was usually on the basis that they were enemies of the people, enemies of the regime, the so-called hostile class. There were three main categories of the so-called Songban, which was the division of the community into categories. Those who were members of the Communist Party of Korea, those who were wavering classes, and those who were hostile classes. And the waverers, but more particularly the hostile, few though they were liable to be put into the detention camps, given virtual starvation rations. Some of the evidence was of a person in the camp whose job it was to collect bodies after the evening roll call, which were thrown out of the huts. And those bodies were put onto wheelbarrows and they were wheeled to vats, and the vats were where the body was reduced to ashes, but not entirely, because extended limbs would sometimes not be reduced to ashes. The ashes were scattered on the nearby fields as fertilizer. So that was all pretty horrifying. The treatment of women was horrifying. The treatment of women in China was also not good, and we drew attention to that. The Chinese have hostility to women who give birth to non-Chinese fathers, and the situation of many women who were coming into China, where they were a precious commodity following the one-child policy. They were Koreans and the fathers were Chinese, but the children could not readily or at all get Chinese papers that would allow them to go to schools. They were liable, once they were detected, to be sent back under a memorandum of agreement to North Korea. And the way they were treated, the way their babies were treated, the way they were bundled back to a country that they greatly feared, that was a horrible story. The abductions of people who, Japanese, especially Japanese nationals, was a shocking thing in this age, that people were rounded up and taken quickly and by boats to North Korea. This was a horrible story. The oppression of political rights and of rights of free expression. The lack of food, the famine situation that has extended now in two tranches. There is a very serious food shortage now in North Korea. So I could go on, but it's all in the report, and it collects the answers to each of the 9 heads, and those reports were then referred from the Human Rights Council with a big vote to the General Assembly. There was an attempt by North Korea and its allies, particularly Cuba and Vietnam, to delay consideration by the General Assembly, but that didn't work, and the Council sent it on to the General Assembly, and the General Assembly exceptionally referred the issue of North Korea, as we had recommended, to the Security Council, which is a very unusual thing. It had only once been done before in the case of Myanmar, Burma. And so that was a step which signaled the resistance to what was happening in North Korea and the insistence that something be done about it.
Yes, thank you very much. Those conclusions of the Commission of Inquiry were very, very significant, and the follow-up by relevant elements in the UN system is an important aspect. Would you comment a little bit more on that follow-up and the prospect for further follow-up?
Yes, I can, because having a beautiful report is unfortunately what some people in the world and in the United Nations think is the whole point of the exercise. But that was never the point of the exercise, or the whole point of the exercise for the Commission of Inquiry. I remember Marzuki Darusman saying to me, we've got to get one really important achievement. And he said, we've got to deal and get progress on the detention camps. Well, we never got to progress on the detention camps. The number of camps, according to evidence that we've heard since our report and according to satellite imagery, the number has reduced, but the general belief is that that has just been a matter of the rationalization of resources, and the number of prisoners hasn't necessarily reduced, but the number of camps has. But the way in which the United Nations on the whole dealt with the report was as good as one can expect in a political organization like the United Nations. There's actually a very good article, even if I say so myself modestly, in the Australian Law Journal, which is published in about, I think, December 2015. And I wrote it quickly, whilst all the facts were in my mind, after the matter had been sent to the Security Council, because I knew the politics of what happened. Australia was a non-permanent member at that time, and our ambassador, Ambassador Quinlan, was really keen to get the report and action on the report, partly, I suppose, because I had been the chair and I knew him, and he wanted to get progress. It wasn't easy because of the geopolitics, but in fact, there's a provision in the Charter, which I'd forgotten. Julia Stone probably taught me, but it's a provision that says that on procedural motions, the veto doesn't work. If it's procedural, it merely requires a special majority. And once you've got that, that is the vote of the Security Council. Now, China and the Russian Federation disputed that having the matter on the agenda of the Security Council was a procedural matter. They said it's a substantive matter, but they didn't fight about that. And in the end, the procedural motion was passed. All of this is described in my article in the ALJ. It really is quite exciting how Argentina ultimately became part of the 10 who voted for the matter to be placed on the agenda. And even the president, who was from Chad, who was really hostile at the beginning to the matter, he must have got instructions from home, and he ultimately voted in favour of the matter going to the Security Council. And so there it is. The report itself was not sent to the Security Council, but because the Security Council doesn't receive human rights reports, at least it hasn't, but the issue of North Korea was put on the agenda, and that is the pathway by which action on the crimes against humanity, which have been found by the Commission of Inquiry, and our recommendation that the crimes against humanity should be referred to a prosecutor of the International Criminal Court. Having the matter on the agenda of the Security Council gives an easy and a direct path to follow up. And that is what the international community promised in 1948 and has reaffirmed in 2010, that crimes against humanity, when they are not attended to by the state concerned, will become the concern of the whole international community, and they will be referred where the state concerned doesn't do it to the Security Council. And they have, that's to say the Security Council has the power, even to non-members of the Rome Treaty, to refer the matter to the International Criminal Court for a prosecutor to decide the prosecutorial discretion and to consider whether the matter should go to the ICC. So it was a very important development, and it's quite exciting to read the story about it. And I was there when all of this was going on, and looked at the negotiations, the way member states were taken to dinner at the Australian ambassador's residence, and how France played a very important role in it as a permanent member, a P5, and how all of this was directed to getting something more than just a piece of paper. We had to get action. We haven't got action yet, but we've got the matter on the agenda, and it will ultimately lead to action, in my opinion.
The way you describe it, it's clearly both it was clearly both a confronting and a very rewarding experience to be the chair of the Commission of Inquiry. And I'm wondering what advice you might have for our students in this classroom if they're interested in going ahead to try and participate in that form of international dispute resolution. What skills and expertise will they require in order to be able to forge a career like you have in commissions of inquiry?
Well, first of all, I've got to say how I got to that point, that I got a tap on the shoulder. Well, you know, it's like Gilbert and Sullivan. It's a matter of polishing up the handle of the big front door. You've got to start somewhere. And, you know, back in the year 1976, the Fraser government had just come into power after the dismissal of the Whitlam government. And the Fraser government gave the Law Reform Commission, of which I was then the chair, the task of investigating and delivering a report on privacy in Australia. And at that time, the OECD in Paris had decided that it would look at the differences that were emerging in the way different countries and groups of countries, the European communities as it was then, and the United States, how they were dealing with, because that had the germs of being a very bad thing for international trade. And therefore, that was the OECD's interest in it. And the secretary of the Law Reform Commission at the time was Mr. George Brower, and he had been one of the secretaries to Cabinet. And he said, what you've got to do, we've got to get the Law Reform Commission engaged with international law, because this is the future. And so he said, you've got to go to the OECD committee and you've got to help in the solution of the OECD, because Australia's a member, and that's what I did. I got involved in that, and that led on to the OECD guidelines on privacy, which became the foundation of our Privacy Act and many other privacy acts, and is still in force. And so that's how I got involved. Now, how do students get involved? Well, I'm going to write an excellent article on how students can get into the United Nations. I'm going to offer it first to the Federal Law Review. It will be the most influential and certainly the most read article I have ever written, because whenever I go to law schools, all the students come up and say, how can we get into the United Nations? Not all of them. There are some who want to get into the Income Tax Assessment Act, but many students at law schools are very interested in this. And the bottom line is, it's very difficult because the UN has a protocol of who it takes, and it's got to share its jobs across different regions of the United Nations, and therefore getting a paid job from the United Nations, you've got to fit into a slot that is available for Australia. And Australians are very keen to be there, and we have a disadvantage in that we don't have dual languages. The Canadians are all taught French, and they speak French, and we don't generally have that. And therefore, that's a disadvantage. But Australians don't have a lot of enemies in the world. And Australians are very hard workers once they get into these jobs. So basically, the bottom line, this is breaking news. The breaking news of my article is going to say the way, if people are interested in getting into the United Nations, is to become a UN volunteer. You've got to get online and see how you can get a volunteer position. This is very unfair because it means you've got to work generally for nothing in what is one of the most expensive cities in the world, Geneva, with the UN Office of the High Commissioner for Human Rights, or more particularly with the human rights organizations of civil society, Human Rights Watch, the International Commission of Jurists, the International Bar Association, Human Rights Institute, Amnesty International. All of these bodies take on young university graduates who work for nothing, and then if they're good and if they've got a bit of luck, they get an invitation and they can get a job in one of the civil society organizations, and then they make representations on behalf of civil society at the council, on the Human Rights Council, and then that gets them jobs in the UN system. It's a matter of carpe diem. It's a matter of seizing opportunities. That's what you've got to do in life. I mean, that wonderful movie by the Australian director Peter Weir, when the teacher got up on the desk and wanted to make a really important point to his students. I'm getting up on the virtual desk and I'm saying, you've got to extend yourself. You've got to put yourself into a position where you will be noticed. It sounds a bit vulgar and a bit crass, but that's the truth of the matter. There are thousands of kids all around the world who want these jobs. And if you're going to get them, you've got to be noticed. And then you generally, Australians do that either by coming later, as I did in the OECD, which is not a UN body, but it sort of led on to other UN jobs, or they go there as volunteers. And that's not an easy thing, and it's an expensive task. And if you set yourself a limit and said, well, I'm going to give this a shot for a year and see what turns up as a UN volunteer, then that's, or a volunteer with one of the civil society bodies, that's how I would do it if I was starting out today. But the Office of the High Commissioner for Human Rights is riddled with Australians. It's riddled with Australians. They're everywhere in there because they're very hard workers and they get up on their French and they can do it. One of my last associate in the Court of Appeal was Simon Walker. Now, he is now the big expert in the UN human rights system on intellectual property and essential medicines. And of course, this has become really important in the last year because of COVID and because of Pfizer and because of AstraZeneca and all of these things we hear about. You know, this is, and he's the big expert that helps the UN to try and overcome the problem for availability of the essential vaccines that will save lives and give people the right to health.
Michael, thank you for sharing so generously about your experiences with the Commission of Inquiry, and that advice is absolute gold to our students who will go out and forge careers in IDR. What we might do now, that we have about 15 minutes left, we might open up for questions from the students so you can engage directly with them. And so I would ask you all to put your questions in the chat and then we'll come to you and you can pose your question directly to Michael Kirby. So I can see in the chat line the first question from Hamish. Hamish, perhaps can you turn your mute off and ask your question directly?
Thank you. Michael, since serving 13 years on the High Court, you've been in several internationally focused roles, including the inquiry on North Korea. My question is, how did you find the transition from a domestic court to working at the UN, and how has your experience working at the High Court shaped your current work style?
Well, don't forget, I came to the High Court after 12 years on the Court of Appeal, and therefore by the end of my time, I'd had basically 25 years as an appellate judge. I was a very experienced appellate judge. I work with very clever people, and but I mentioned to you that the report of the Commission of Inquiry on North Korea was unanimous. There was no dissent. And there was no dissent in my work on the Law Reform Commission. There was little dissent in my work on the Court of Appeal. There was no dissent in the Solomon Islands, no dissent in any of the UN bodies that I worked in. But in the High Court, there was a San Andreas fault, as I would always describe it, and therefore I was often in disagreement. This is a rather painful situation. Please don't think that is a nice thing to be working in a very important institution where you're in disagreement. It adds not only to intellectual challenges, but also to emotional challenges. You've got to get by and be professional and agreeable, but you just have deep disagreements. And the case of Al-Kateb against Godwin, which is a case in 2004, which is relevant to international law and its role in Australian law, is an instance of that. So I learned to deal with a lot of difficult problems, and that really helped me in my work on the UN and other international bodies. I work with brilliant people and honest people, but I had much more support for my opinion about the way international law is seeping into every aspect of law, and that this is something that is beneficial, it is inevitable, it is tied up with the technology, with the trade, with the internet, and it's natural and it will come and is coming. But that was not something which my colleagues on the High Court really agreed with. Justice McHugh, a very dear friend and colleague from the Court of Appeal days, he said it was heresy. And there's a very good article that's just been published by me in the University of New South Wales Law Journal on Al-Khateeb and why the minority view will ultimately prevail. But that's the transition. But it's a somewhat painful thing to talk about. But honesty requires me to give you that answer. But if I'd had the experience on the High Court that I had in the Court of Appeal or elsewhere, I would not have been the great dissenter at all. I would have just been the great affirmer. I would have been going along with everyone else. That was what happened in the Commission of Inquiry on North Korea. It was unanimous.
Great. The next question is from Ava. Ava, could I ask you to go off mute and, if possible, turn your video on? Great, thank you.
Hi, thank you so much for your insightful discussion. My question is that what lessons can Australia learn from international inquiries and international human rights bodies about our own contraventions against human rights, particularly towards refugees and asylum seekers?
Well, Australia did have a principle at one stage that we always tried to conform to UN Human Rights Human Rights Commission's decisions and the Human Rights Committee. But more recently, we haven't been quite so upfront in agreeing with and applying the decisions of the Human Rights Committee set up under the International Covenant on Civil and Political Rights. And we've just begged to differ. This is generally in relation to refugees and in relation to offshore detention of refugees. It strikes me as rather unremarkable that international bodies will find that if you have agreed to the International Refugees Convention and Protocol, and then instead of fulfilling the obligations of that protocol when people arrive at your doorstep and ask for refugee status, that you will send them to somewhere else, a different nation. And in a couple of cases, you'll attempt to send them even to a nation that is not a party to the Refugees Convention. How can that possibly be compatible with the language, let alone the spirit of international refugee law? So what can Australia learn? Well, Australia can learn that we are a generally human rights respecting country. But we're better at protecting the human rights of the majority than we are at protecting the human rights of minorities. I know that because when I was growing up as a young gay man, I knew the criminalization of people like me. And that is a shocking memory and is a scar on my memory that is something I had to go through. That particular scar has been removed, but it's a feature that you don't forget. And therefore, you try in your life to avoid being involved in similar conduct. Sometimes, if you're a judge, you can't avoid laws which you don't agree with. You just have to give them effect because that is the rule of law. And a very good illustration of that is the case of Minister for Immigration against B. But there are still leeways for choice. That's what Julius Stone taught me in fourth year of my law course back in the year 1961. He said, judges have leeways for choice. The leeway is presented by ambiguity in the text of the Constitution, ambiguity in the statute, or uncertainty in the judge-made law, and that's where judges have to fill the gap, and they can do that, including by reference to international human rights law, which after all, is what was done by the majority of the High Court in Mabo. They didn't just go on applying the denial of the Indigenous rights by reason of Indigenous status. The majority said that would be totally incompatible with the fundamental rights of civilized countries. And the majority, led by Sir Gerard Brennan, before I was on the High Court, upheld the right to Indigenous people to access to their land rights. So this is what we've got to do more often in Australia, and we've got to be more conscious of it. And you, the law students of today, have to ask questions about it. I never asked a question about Aboriginal rights when I was at law school. Never. I never asked a question about women's rights and injustice. I never asked a question about the White Australia policy and racial prejudice in law. And I never asked a question about LGBT rights, even though it affected me personally. I was quiet as a mouse on those subjects. Well, you've got to lift your voices, and you've got to go on doing that all your lives, including when you ultimately become a judge. And if any of you do become judges, remember that I told you that that is what Julius Stone taught me, and I didn't implement it as a student, but I did endeavour to implement it later when I became a judge.
Thank you for that heartfelt and lived advice on how we should all ask questions and challenge the injustices that we see. We have 3 more questions, Michael. What I might do is allow our students to pose those. Oh, I see there's 4 now. If you could pose your question as concisely as possible, and we'll allow you, Michael, to choose how to respond, and how concisely or generously. So if I could now go to you in turn, I'll go to Sophie, Georgia, Helen, and Adelaide. So if you could turn your mute off, your video on, ready to ask your question, and pose it as quickly as you can, that would be awesome. So Sophie.
Hi, thank you, Justice Kirby. My question just is, when you're working on particularly controversial international issues, are you ever worried about like negative repercussions either for your work in the future or for you personally?
Sorry, I'll let all the questions come out if that's okay with you, Michael.
Yes, good idea.
So Georgia.
Hi, thank you so much for sharing. My question was just about the pace of change and how you maintain hope when the pace of change in international dispute resolution is sometimes quite slow.
Yes.
Thank you, Georgia. And Helen.
Yes, thank you for your time. My question is just what you described about the situation happening in North Korea seems very similar to what many believe is happening to Uyghur Muslims in China. I was wondering if you believe a similar inquiry could ever take place with the situation in China.
These are all terrific questions. Thank you.
Right.
And now, Michael, sorry, now Adelaide has a final.
I'm sorry.
Sorry.
Hi, sorry, last question. I was just wondering, like, about the relationship between Australia and China and how that might have been, was there political resistance when you did make those recommendations to China in the inquiry, and did it challenge the independence of the inquiry, given that you are an Australian? And how might the response be different in contemporary Australia-China relations?
Great. Thank you all for those wonderful questions. And Michael, you just have a couple of minutes. So
yes,
if you wish to navigate your responses, we're in your hands.
First of all, in relation to retaliation against me personally, that was a risk, and it was taken into account. The murder of the half-brother of the Supreme Leader, Kim Jong-nam, at the international airport in Kuala Lumpur indicated that this is not just a theoretical risk, this is something that has to be taken seriously. So certain procedural steps were taken. We had a single UN guard at our public hearings. The UN opposed the public hearings because they said it had never been done. They were very Napoleonic in their approach, but you'll be at risk. We can't defend and protect you. We said we're prepared to take the risk, and so we went ahead with them anyway. but nothing untoward happened. And of course, the eyes of the world were on our inquiry, and that, in a sense, was a protection. And I think people who get involved in UN inquiries just have to be brave and have to be willing to do what has to be done. Secondly, the pace of change and how do I keep hope in international developments? Well, if you go back to when it really began in earnest after the Second World War, the Universal Declaration of Human Rights, I got a copy of that at the Summerhill Opportunity School in the New South Wales school system from my teacher, sent by Dr. Evatt, who was the foreign minister at the time. And that showed me, and the teacher, Mr. Gorringe, told us how important it was to pay respect to this. And therefore, I sort of was there at the very beginning. And I knew the man, John Humphrey, who was a professor at McGill University, who actually wrote the first draft of the UDHR for Eleanor Roosevelt. So, you know, I've really had a very blessed life and have seen how it has all developed. You cannot but have hope, and you cannot but have optimism when you're faced with disappointments, but when you see what can be done. And read that article in the ALJ, because it shows how ultimately the angels succeeded there. And nation states are no angels, but sometimes they do the right thing. And I think demonstrating the wickedness and the wrongness and the cruelty of North Korea had a very big effect. And that's the value of a commission of inquiry. As to the Uyghurs and other cases, well, all of those are matters that will be or should be raised in the Human Rights Council, and I would expect that they will be. Of course, China is itself a P5 member. It has a veto power, and it may be that views will be taken that this is not something where progress can be made by the processes of commissions of inquiry. But I have had enough problems with my challenges, which have included North Korea and Cambodia, and I don't need to add other really difficult challenges like the Uyghurs and China, so I won't say any more about that. As to China, at the time of the Commission of Inquiry, did not have any particular animosity to Australia, but they did have animosity to the Commission of Inquiry. I think that's fair to say. They refused to receive us. The Russian Federation, by contrast, were very professional. But the Chinese assigned a junior officer to meet the Commission of Inquiry. They wrote a letter and insisted that it be annexed to the report. It was annexed to the report. It was a letter which said these are not refugees, they are commercial people who are trying to jump the queue. And I'd been through all that, and I'd heard that in the Australian context, so I was up to dealing with that. But we dealt with China in a professional way. China kept saying, we do not agree with terms of reference that are referring only to nation states. We do not think that is the way to go with human rights, and they were adamant about that. But they were outvoted at every time there was a vote for postponement, vote for delay, vote for no reception by the Security Council. The overwhelming majority said this is very serious and it has to be attended to under the promise of humanity to look at and respond to crimes against humanity. And I hope that that will always be the principle, because otherwise we have not learned anything from the terrible wrongs that were done by the Nazis and by others during the Second World War. And that is the obligation of humanity. That is what Eleanor Roosevelt taught, that is what Dr. Everett taught, that is what John Humphrey taught, and it's what the Commission of Inquiry on North Korea taught. And I hope that the young Australians who are listening to this will continue that instruction, because otherwise the risks, especially of countries which are armed with nuclear warheads, as North Korea is, the risks are enormous and existential to the human species. So we owe it to each other and to all people and all living things on the planet to respond effectively to the challenges, including the challenges of human rights. And that's why studying human rights is so important, and why domestic courts have to be knowledgeable about what is happening in our world, because it is the context in which our domestic law now has to be understood.
Well, Michael, thank you so much. We've reached our time limit now. So in conclusion, I would just like to thank you very warmly on behalf of all of us for your very comprehensive presentation and the insights that you provided in relation to the Commission of Inquiry mechanism. Your responses to the questions and remarks generally, which reflect not only a great deal of substance, but also wisdom and pragmatism. And so perhaps ending on a positive note too, students, I would very much endorse your suggestion and recommendation to them to lift your voices as we move forward. So thank you so much, and all the very best to you. It's been a pleasure to engage in conversation with you. Thank you.
Thank you very much, Richard. Thank you, Jeremy, and thanks to the students of the Australian National University. And I wish you well, and I'll be back next year and looking forward to being able to report real progress on the Commission of Inquiry and many other things.
Thank you so much, Michael Kirby. And I might ask all the students to turn their mutes off and just give a brief round of applause to express your appreciation.